Down and under it, just a twisted pink paper clip, clinging to a hated jacket zip. Know that you won't get an acquit. Yeah, know that the hour is drawing near. The case is resting, Sarah Boone should fear. She might soon be shedding actual tears. Down and under it, just a twisted pink paper clip, clinging to a bit of jagged zip, doing nothing more than slip and stick. As Sarah tries to hide her abusive lies, but know that no, it's you, Sarah, we all despise. Leaving you with your lifetime of demise from your sad attempts being the victimized. Know that, yeah, know that. All that you're really gonna see is Prosecutor Jay giving proof to the jury of your murderous pine for commissary. 6-panel conviction arrived at convincingly. Oh, Sarah, can't you tell that your time has come to ring the bell? And let your fans owe you some small slice of hell. The bailiffs will be waiting, cuffs in hand, since you fumbled and flopped all over the stand. So go on, say bye to your circus jaunt. Go on ahead, keep pretending to flit and flaunt. You'll soon be in your brand new prison haunt. Damn it, Margaret. Oh, Sarah, know that now is your time to return to your jailhouse lies. Your face and sob story past its prime. Yeah, know that. All that you're really gonna see is Prosecutor Jay convincing the jury of your murderous and dangerous lies. A sad attempt at trying to be the victimized. No, not happening on board DAJ Enterprise. Clip, clinging to a bit of jagged zip, which does nothing more than slip and stick. As Sarah tries to hide her abusive lies, but know that no, it's you, Sarah, we all despise. Your angry and controlling attitude won't spare you any grace or fortitude. From the truth, the jury all can see that the time is here, your taunts aside, to return to your crummy jail slide. Your face and sob story are past the prime, so go on, say bye to your circus jaunt. Go on ahead and keep pretending to flit and flaunt, because you'll soon be in your brand new prison haunt. Damn it, Margaret. Just a twisted pink paper clip, clinging to a bit of jagged zip. Yeah, know that you won't get an acquit from all your murderous and dangerous lies. Pathetic, you claim to be the real victimized. No, not happening on board DAJ Enterprise. Damn it, Margaret.
Good morning, y'all. How is it going? What happened yesterday afternoon was just more than we thought was gonna. I mean, even us, we've been like all of us that have been on this trial since I wouldn't say we have, maybe not necessarily day one, but over the last year, we've really been into this trial. We've picked and pointed at all the different details, right? I was not prepared for that, you guys. I did not think it was that bad. They're saying that they might be able to have closing arguments in the afternoon. Again, they said that about yesterday, and we know what Owens pulled. So I don't know what to expect. I don't know if the jury will be going into deliberation by the end of the day today. I really don't. I kind of want them to do it on Monday. Just to be honest with you guys.
This is a box. This is the box where Jorge Torrez was killed. It's a small box, 28 by 20 by 8 7/8 inches. Jorge Torrez was zipped up in this box. Jorge Torrez took his last panicked breaths in this box. The medical examiner explained to us that with each breath Jorge Torrez took in, there was less oxygen in this box. Jorge Torrez was murdered in this box. Ladies and gentlemen, on behalf of myself, my trial partner, we thank you for your time and attention in this most important of trials. We now have the law from the judge in this case. This is what our duty is to follow. And let's have a discussion regarding that law that we've just been read and given. The first section of note we're going to come to is called Introduction to Homicide. But this being a legal document written by a bunch of lawyers who you've seen for the last 2 weeks arguing with each other, pay careful attention to ands and ors. Remember, if an and is somewhere, we're going to need both things or all the things, and if an or is there, then only one of those things we're going to need. So as we start out here on Introduction to Homicide, we come to the first section on justifiable homicide. And it reads, the killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time. Ladies and gentlemen, this section is completely inapplicable. It's inapplicable because Jorge Torrez was zipped up in that suitcase. He couldn't commit or attempt to commit a murder on anybody. He couldn't even scratch his own head while he was in that suitcase. Next, we turn to excusable homicide. Here we have several paragraphs, and it reads, the killing of a human being is excusable and therefore lawful under any one of the following three circumstances. When the killing is committed by accident and in misfortune, doing any lawful act by lawful means, usual, ordinary caution, and without any unlawful intent. Well, the problem in this circumstance for the defendant is that she took the law into her own hands. her testimony was that when Jorge Torrez was in here, he was laughing and giggling and they were joking. And then he started to complain that he couldn't breathe. And that's when she said that she wanted him to stay in there so he could feel uncomfortable. So he could feel her grievances. Ladies and gentlemen, that is not lawful. That is not the use of ordinary caution. And that is not applicable in this circumstance. Second, when the killing occurs by accident or misfortune in the heat of passion upon any sudden and sufficient provocation. Jorge Torrez couldn't provoke anything from his circumstance. Jorge Torrez was confined to this box. Next, when the killing is committed by accident and misfortune resulting from a sudden combat, a dangerous weapon is not used, the killing is not done in a cruel and unusual manner. This fails on 2 counts. There was no sudden combat. In her words, this was laughing and joking and we're all having fun when she decides that it's going to get a little extra real for Jorge Torrez. And it fails on the 2nd count because Jorge Torrez was killed in a cruel and unusual manner. Next, we turn to our main charge, 2nd degree. And the law informs us that to prove the crime of 2nd degree murder, the state must prove the following 3 elements beyond a reasonable doubt. I think it's important to stop right here. This sentence right here is telling us what has to be proven in order for the crime of 2nd degree murder to be, for the defendant to be found guilty in this case. We've been hearing all kinds of facts for almost 2 weeks now of trial, but these are the 3 facts that had to have been met by the reasonable doubt standard in order to be found guilty. Ladies and gentlemen, I submit to you that the state has proven 2nd degree murder beyond all doubt. And the proof of that guilt is overwhelming. But I will cite for each element just one fact that conclusively proves each of those elements beyond all doubt. As to the first fact, that Jorge Torrez is dead, well, we have stipulation, amongst other things, that agrees to that. As to the second fact, the death was caused by Sarah Boone. Sarah Boone, in her own words, from the time that this case began on February 23rd, 2020, to when she took the witness stand a few days ago, was consistent about one statement. She zipped him up. She didn't zip him out. She zipped him up in the suitcase, and she refused to zip him out. 3, there was an unlawful killing of Jorge Torrez by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. The law goes on to define for us what a depraved mind is, and also what an act is. It's going to tell us that an act includes any series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another in demonstrating a depraved mind if it is an act or a series of acts that one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself displays a difference in human life. Ladies and gentlemen, her conduct fits every one of those things. And if there was a scintilla of doubt that this was not the actions of a depraved mind, I point to you. IMG 1062, states 17. Mr. J, may you publish states 17?
Shallow.
For everything you've done to me.
Shallow.
For everything you've done to me.
Shallow.
Fuck you.
Shallow.
Fuck you.
Shallow.
Stupid.
Shallow.
That's my name. Don't wear it out.
Shallow. I can't fucking breathe, babe. Seriously.
Yeah, that's when you do and choke me.
Shallow.
Owens just said something. You knew he was going to interrupt this, you guys. Oh, no. See, his mama's never seen this, you guys. She's never watched that video. Bless her heart. Now, stupid writing. Oh, she's passing notes. Of course she is. She shows zero remorse. This jury is going to see this, you guys. Acting like this when she should just be sitting there, looking forward, being still.
You may continue.
Zero respect.
Sarah. Sarah. Sarah, I can't breathe, baby.
That's on you.
Sarah, I can't breathe.
It's on you.
Sarah.
Real or ransom. Now you want to give it for it extra. Because I got it.
Sarah.
Real or ransom.
Sarah. Sarah, I can't breathe, baby.
Oh. That's what I meant like when you jingle me.
Sarah.
Fuck you.
I can't breathe, Sarah.
Yeah. You should probably shut the fuck up.
Sarah.
Ladies and gentlemen, that exhibit removes any scintilla of doubt about the depravity of the defendant's actions. But we know from the evidence that this was not the first time she had considered killing Jorge Torrez. We know from the evidence that on January 13th, 2020, approximately 1 month prior to Jorge Torrez's murder, the defendant had a text message conversation. Please do something with yourself, Sarah. God bless you. And bless you and all of you too. I'll get rid of him. Then I'll be better. Torrez. But ladies and gentlemen, in this case, the law actually specifically tells us that the intent to cause death is not necessary. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Next, we turn. I'm going to bypass the lesser included offenses because though she is guilty of those offenses as well, the law instructs us that she is to be convicted of for the highest offense in which the evidence supports, which is second-degree murder in this case. So turning our attention towards voluntary intoxication. If there was any question about the fact that Sarah imbibed alcohol on the night that Jorge Torrez was murdered, and that maybe somehow that would excuse the conduct or be some type of defense for the conduct. Well, this tells us that that's not the case. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that she lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication. Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence. Ladies and gentlemen, there's ample evidence of the defendant's intoxication from watching her on the public surveillance, buying the bottles of wine with Jorge Torrez, to her admissions to drinking, to her voice that we heard on the video while she was torturing Jorge Torrez. Next, we come to defenses. First, we come to the justifiable use of deadly force. It tells us it is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone were justifiable use or threatened use of deadly force. Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. The law on the justifiable use of deadly force is as follows. Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent the imminent death or great bodily harm to herself. Sarah Boone had no duty to retreat. Ladies and gentlemen, in a few moments, Mr. Owens will rise. He is going to show you this. And this. And this. And he's going to talk in this as well about the list of grievances that Sarah Boone had for Jorge Torrez. He's going to talk to you about curtain rods. He's going to talk to you about black eyes. He's going to talk to you about what an awful, awful boyfriend Jorge Torrez was. And ladies and gentlemen, at the end of all of that, it still will not change the fact that the defendant is not entitled to the justifiable use of deadly force. Because as we continue to read this instruction, it tells us in deciding whether Sarah Boone was justified in using the use of deadly force, you must consider the circumstances at the time the force or the threat of force was used. Danger need not have been actual. However, To justify the use of deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed that deadly force was necessary. Moreover, to justify the use of deadly force, and this is important, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. Ladies and gentlemen, no reasonably prudent and cautious person would believe that a man who could barely fit into this box, who was incapable of movement, who was begging for his life, who was slowly asphyxiating, suffocating with each breath, would have needed to use deadly force against him. The justifiable use of deadly force utterly fails, utterly crashes like a house of cards. But there's more. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself. Let's stop there before we consider the next two paragraphs. Some of the most critical testimony in this trial is her testimony on the stand. It was a great day. We were doing puzzles and artwork, dancing with the dogs, listening to music. Tag, you're it, hide and go seek time. George gets into the suitcase. She comes and zips him up. But we're still laughing about it. We're still laughing after he's zipped up in the suitcase. And then that's when George had the temerity to ask, Jorge Torrez had the temerity to ask to be unzipped from the suitcase. And that's when Sarah Boone decided he needed to suffer. She was the initial aggressor, ladies and gentlemen. She provoked the use of force in this case. In her own words, we were laughing and playing right before he wanted to be let out because he couldn't breathe. Paragraph 1. The threat of force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using deadly force on Jorge Torrez. He couldn't exert anything, ladies and gentlemen. Jorge Torrez couldn't even exert his arm out of the suitcase. How on earth could he have exerted a force so great to justify his... Judge, I object.
Approach.
Well, we knew he's going to do it at least one time, didn't we? What was he saying? To exert enough force to get out of the suitcase? I didn't know you were in pre-law. Michael. They think he's saying things with too much emotion. I don't think so. He's objecting to how he
Objection
said
overruled.
the effort or whatever.
This is of no help to the defendant. Second paragraph. In good faith, Sarah Boone withdrew from physical contact with George Torrez and clearly indicated to George Torrez that she wanted to withdraw and stop the use of deadly force, but George Torrez continued or resumed threatened use of deadly force. Ladies and gentlemen, George Torrez never got a chance to do anything. George Torrez never was able to mount any aggression towards the defendant. Therefore, this paragraph is inapplicable. And the law tells us as well that physical contact in this case includes any restraint on George Torrez's movements. The law also tells us, again, you find that Sarah Boone, because of prior threats or difficulties with George Torrez, had reasonable grounds to believe that she was in danger of great bodily harm, of death or great bodily harm at the hands of George Torrez. You may consider this fact in determining whether the actions of Sarah Boone were reasonable. Now, we're going to get to battered spouse syndrome in a moment. But again, I submit to you, this will be the opportunity for the defense to air grievances in regards to George Torrez. But again, those grievances will not change the law, and they will not change the fact that the justifiable use of deadly force fails as a defense for the defendant. If you find that at the time of the alleged second-degree murder, manslaughter, culpable negligence, Sarah Boone knew that George Torrez had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. Considering the issue of deadly force, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torrez. Now we come to the the special instruction on battered spouse. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find Sarah Boone suffered from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether, in Sarah Boone's circumstances, would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torrez. Like other witnesses, you may believe or disbelieve all or any part of the testimony in regards to battered spouse. So we heard from 3 experts in the areas of battered spouse in this case. And I think at the outset, it's important to note what battered spouse is and isn't, and what the law instructs us here. Battered spouse is not some carte blanche. Battered spouse is not a license to kill. The fact that Jorge Torrez at points mistreated Sarah Boone, did things that were worthy enough to get him arrested, to get restraining orders placed upon him, doesn't mean that she walks around with an ace in her pocket when it comes to Jorge Torrez. It doesn't mean that because he did these awful, bad things, that now, through the rest of time, she's a battered spouse and she just has the right to kill him, or to make him suffer, or to punish him, or to make him feel uncomfortable, or decide that he needs to be confined to a box. No. What the battered spouse syndrome instruction does is it talks about the imminency of fear. And when we heard about that testimony, we heard about it from Dr. Harper, and we heard about it from Dr. Brannon for the defense. And some of the testimony was a little difficult to understand at points, but there was one point in Dr. Brannon's testimony that was very critical. Dr. Brannon talked about rule-outs. He talked about the fact that when emotions and emotional reactions are involved, like trauma and trauma-based disorders, other possibilities have to be ruled out before we can even ascribe those actions to battered spouse syndrome. Other possibilities, according to Dr. Brannon, include alcohol abuse. Dr. Harper should have listened to Dr. Brannon's testimony, because Dr. Brannon completely undercut Dr. Harper's testimony. Dr. Harper relied heavily on the words of the defendant, who was abusing alcohol at the time of these events. And then you heard from the expert for the state, Tanya Warner. In her opinion, was much more straightforward. Remember, Dr. Brannon did not render an opinion as to whether or not she suffered from battered spouse. Dr. Warner said affirmatively, yes, I believe she did suffer from battered spouse syndrome. But she also applied what Dr. Brannon was talking about. Other possibilities have to be ruled out as the trigger for a behavior, for an event. So, in Dr. Warner's estimation, the fact that at the time of this incident, they were laughing and joking and carrying on meant that the trigger was not domestic violence or some threat. In the defendant's own words, the trigger was him wanting to get out and her being reminded of the bad things that he had done to her. That's not imminence of fear. That's reminder of bad things a person has done. And again, even if you were to believe that she was battered spouse triggered at the time of this event, it still does not save the day. Because all the battered spouse trigger law tells us is that it goes to that imminency requirement. It doesn't say there's no imminency requirement. It doesn't say that, look, if you're suffering from battered spouse and you're triggered by battered spouse, then, hey, there's no more imminency requirement, do as you wish. It just gives the ladies and gentlemen of the jury another thing to consider in determining whether or not that threat was imminent. And we know from the evidence, we know from the videos, there was absolutely no threat. And we know there was no threat because Jorge Torrez never got out of that box. He was never got out of that box until sometime on the early afternoon of February 24th. Mr. J, can you please publish from stage 21?
I'm going to go to court and I'm going to tell the judge, listen, my fiance has nothing to do with it. It's all my fault. We were both drinking and got out of hand. It's an isolated situation. It has never happened before. I love my fiance. She's a good woman. Never been in trouble in her life. She has a 7-year-old son that she loves and cherishes.
A blind Boston Terrier.
She has 2 dogs. One is blind, one is deaf. She goes around and she's driving and sees an animal that's injured. She'll stop in the middle of the street, no matter what kind of traffic it is, just to make sure that that animal doesn't get injured any more than where it already has. We both love each other. We both live together. Yes, every relationship has their arguments, but we are not the type of people that you guys are portraying us to be.
She
Especially her. So please, if you can,
dismissed.
dismiss this case.
Closed.
Drop it. She is not the type of person.
Good person.
Great person.
Angel.
I know she'd be an angel. She's close to it.
Best thing that has ever happened to you.
Yes, ma'am. And I love you to death. And I hate that we're going through this right now.
Sonnet.
What?
And they could.
I love you. What else you want me to say? God will prevail and He will take us out of this situation. Love you.
Clearly, Jorge Torrez is dominating the defendant. Clearly, Jorge Torrez is the one telling the defendant what to do. Clearly, Jorge Torrez is the one calling the shots at 4748 France Lane. Ladies and gentlemen, are we so sure that Jorge Torrez wasn't the person suffering from battered spouse syndrome? Next, we're going to come to the justifiable use of non-deadly force. The language and the arguments are pretty close to what we've already heard in the deadly force instruction, including the key language that it requires a reasonably cautious and prudent person under the same circumstances would have believed that the use of non-deadly force was necessary. Ladies and gentlemen, I submit to you that this was not a case of non-deadly force. Jorge Torrez lost his life as a result of these actions. We have heard the testimony of Dr. Sarah Zadovich, who described his cause and manner of death, who described the mechanism of death, how that oxygen dissipated in that suitcase. And when we also look at the imminency, we heard in opening statements by Mr. Owens that, the big threat in this case, the awful threat, was in the magic 9 minutes between the video at 11:12 that she took, torturing Jorge Torrez, to her follow-up video at 11:23, after she had moved the suitcase. Mr. J, can you publish from States 17, IMG 1063. It was a short video. Well, what's one of the things that we notice by this point? You can hear how loud George's voice is on the 11:12 video. But now, roughly 11 minutes later from the time that started, you see that the makeshift coffin that he's in has been moved. And his voice now is softer. The life is draining from Jorge Torrez, and it's evident in that video. And that, ladies and gentlemen, is evidence that there was no threat in the magic 9 minutes that was not recorded. There was only Jorge Torrez in this box, slowly being killed. Next, we come to weighing the evidence. This instruction tells us it is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witness acted as well as what they said. Some things you should consider. Did the witness have an opportunity to see and know the things about which the witness testified? In focusing on the defendant, absolutely. Two people walked through the front door on the evening of February 23rd, 2020 at 4748 France Court. Jorge Torrez and Sarah Boone. But only Sarah Boone ever walked out of that front door alive. Did the witness seem to have an accurate memory? This is an emphatic no. And the litany of her intoxication in versions of events is evidence of that. Was the witness honest and straightforward in answering the attorney's questions? I would submit to you she wasn't. 4, did the witness have some interest in how the case should be decided? Clearly. Does the witness's testimony agree with the other testimony and other evidence in the case? And I would say largely no. Because on the issue of whether or not Jorge Torrez could have threatened her the way she says that he did, the answer is clearly no, and we know that from the forensic data. We know that from the items itself. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? In regards to the defendant, it's almost more appropriate to ask about the time she did make a consistent statement. You listen to her version of events on the 911 call, on the body cameras, on her first interviews with law enforcement, and then you hear her in her next interview the next day with Detective Copsell and Detective Lowen, and more details come out, things change. First, she was never intoxicated, then she was intoxicated. Then there's just the whole fact of she omits the fact of, oh yeah, he was actually trying to attack me. Oh yeah, I was in fear for my life. When she said at every turn, no, it was just a great day. We were having fun. Oh my God, I can't believe this. We were doing good. The only stress we had was about jobs. And now, 4.5 years after the fact, it's time to come up with a new story. But ladies and gentlemen, I submit to you that the truth does not change. The facts do not change. The videos do not change. And on any version of events that the defendant has given, they all add up to the fact that there is absolutely no doubt that she is guilty of murder. I ask you, ladies and gentlemen, do you have any doubt about the defendant's guilt when she described using that baseball bat to hit Jorge Torrez's fingers back in the suitcase when he attempted to save his life? Do you have any doubt when she is given how many versions of events in this case? Do you have any doubt after hearing the testimony of her neighbors about the loud crash and the arguing that night? Do you have any doubt after hearing the testimony of Dr. Sarah Zadovich? Do you have any doubt after watching the videos of Jorge Torrez being murdered and her laughing about it and talking about the fact that he cheated on her? Do you have any doubt after reading the text messages from her phone, after seeing the videos of how she controlled and manipulated Jorge Torrez? And if you say, Mr. Cacciatore, I still have a doubt, well, then the law asks you, is that doubt to an element? And is that doubt a mere possible doubt, a speculative, an imaginary, or a forced doubt? I submit to you the idea that she had to do this because she was a battered spouse is an imaginary doubt. It's a doubt born from the imagination of Sarah Boone. It is not a reasonable doubt. But if you find yourself back in that deliberation room and you are just trying to think of some way in which the defendant is not guilty, just searching, struggling for that way, that also is not a reasonable doubt, ladies and gentlemen. That is a forced doubt. Ladies and gentlemen, I'm confident that when you read the entirety of those jury instructions and apply the law to the facts that came out in this case, that you are going to come back with the only lawful verdict, which is guilty as charged, second-degree murder. Thank you.
Members of the jury, it is 4:04. As I promised, we were going to take that afternoon break before the defense proceeds with their closing argument. You're going to leave everything behind. Similar instruction that I've given you before. Please don't conduct any independent investigation, research as to the person, places, thing, or charge involved in this case. Do not have any discussions among yourselves or anyone else. We'll bring it back in about 15 minutes. Thank you very much.
All rise. We're exiting.
How you feeling, Sarah? Not looking too good. Actually, she looks a little white there. Kind of losing all that color. Mackenzie, thank you so much for your super sticker. And yes, amen.
Y'all may be
Justice
seated.
for
Thank you.
George.
Judge, I've got a motion.
Okay, may proceed.
Sarah Boone's entitled to a fair trial. I think that right's been compromised here today. I don't know who's scheduled to put the two detectives on the front row with the Torrez family, the family of the victim. But they had to have known to tell them that the Suitcase video, which has been around for 4.5 years, was going to be played during opening statement. And the state attorney's office or the sheriff's department had to advise them, or the victim's advocate had to advise them, that if they couldn't take it in front of a jury that's trying to decide the case, they needed to get out of the courtroom. Now, what happened here today should not ever happen. There should be safeguards in place. There's no room for this after 2 weeks of a murder trial for something like that to happen. One of the Torrez members of the family audibly, during the 2-minute Suitcase video, expressed some kind of emotional reaction. I look back, he or she were bent over in agony, physical pain. The physical pain followed the audible announcement. You can't unring that bell. That's their responsibility to ensure that kind of thing doesn't happen, especially when they know they're going to show a video and the family of the victim is on the front row. I've never heard of such. I asked for a mistrial.
Response.
I've never heard of such a request. The victim's family has the right to be here. They were advised as to what will be used during closing arguments. I cannot make a decision for the victim's family and the homicide survivors as to whether or not they believe they can handle it. She clearly, or he, I don't know, couldn't, and I believe the appropriate thing was done. They left the courtroom. But again, to say this is intentional sabotage and all the accusations that continuously get made are unsubstantiated. And it does not warrant a mistrial. People get warned, and sometimes they misjudge their own emotions. I don't understand what test we are expected to run on homicide survivors. So the motion should be denied.
Motion's denied. Jury's going to be back in about 13 minutes, counsel. So we'll reconvene at that point in time.
Could the state put the Suitcase back in the water?
Yeah, can we clean the well from the state's materials, please? Thank you. State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? Thank you. Y'all may be seated. Members of the jury, for one of the last times, if you could, please raise your hands to confirm that you complied with the court's instructions. All hands have been raised. Members of the jury, at this time, the defense is going to proceed with their closing argument, similar to the state's closing argument. These are not evidence. These are just arguments, and I ask you to pay attention to them. Thank you. Mr. Owens, you may proceed, sir. Yes, sir. Thank you.
Ladies and gentlemen, good afternoon. Y'all know me, I'm James Owens, along with Tony Henderson and the girls, we're all from Milton. I think y'all figured that out, that we were from out of town. Santa Rosa County, it's northwest Florida, close to Pensacola. And my buddy Kevin Beck, he's a longtime friend, he's from New Mexico. The team, the defense team, is here, and we're here to represent Miss Sarah Beck. And we feel confident that we're going to be able to show you why she's not guilty. Okay? Now, I'm going to take my time. I've got some notes. I'm not the most organized person in the world. I've got some exhibits that we're going to show you. And then we got a couple of videos at the end. Okay? And we're going to try our best to help you make the right decision. Okay? But yeah, Milton's a small town.
Objection. Providence.
Overruled.
I'll tell you how small it is. 7 miles away is another small town called Pace. In between that is a Walmart. Very small town. We didn't know what to expect coming down here to Orlando.
Providence.
Judge, I'm allowed to.
I'll give you a little bit more for intro, but then we need to get into it.
I'm going to get into it, but I wanted to say, it's a small town, good people. We've been down here 3 weeks. We didn't know what to expect. We've been surprised. From
Objection. Improper argument.
Mr. Owens, approach.
Do we need to send him back to law school and tell him how to do a closing statement? Whoever just told me they sent me an important email, I don't have it. But you're not the first person that said they tried to email me in the last 2 days and it's not going through. So I don't know what's going on. It is a Google email. I'll check my DMs as well on Twitter and Instagram, but that's the only other way to message me. I don't have anything new.
Objection's overruled.
all I wanted to say is just, since we've been here, we've been treated with respect and hospitality, and just like we've been at home. We appreciate that. Now, I'm going to do some reading, and then I'm going to do some talking. But ultimately, this is about justifiable use of force. That is a legal defense in Florida. We as citizens, the law is designed to protect us from defending ourselves, to protect us from potential attack. And you are the only ones, in this case, because Sarah Boone was arrested, that's going to be able to look at it critically and objectively. Objectively. Not like the state attorney.
Objection to improper argument.
Overruled.
Objectively. And the law in Florida gives y'all the power and authority to do that. The state attorney can't make the decision. They can't make the decision. They can try to influence you. And we're going to talk about some of the things they did here in this trial and some of the things they said.
Objection. Objection. Can we have a motion?
Yes.
Wow. I wonder, I'm surprised that they're doing this, but I think they're doing this on purpose. Anybody else think so? Look at you guys. This is great. Isn't there, okay, so I'm not an attorney, but isn't there some kind of something between attorneys where they talk about the fact that, you know, it's kind of a no-no, that you don't do this, you don't object in closing, and this part is good TV, Carrie. I know it is, but I'm just saying, like, isn't there something in the legal world that says you have some respect unless people are completely off the rails? I feel like Owens has done so many sleazy things, and I'm using Wendy's term here, in this trial that the state's giving it back to him right here and now. They're like, this is our last shot. They're probably going to drive him to the airport when this is all done. put his butt on a plane and get him out of here. Let's see. Thank you, Sean. You became a member over at Buy Me a Coffee. Thank you so much. Oh, James Michael Simmons, you had already sent me that picture before. You sent it to me on Insta and you sent it to me. I've seen it. You sent it to me before. We put it up before. Okay, I don't see. Is Owens not intentionally stalling? Yeah, at this point, why would be though? I mean, everything's got out there. Like, what could he
proceed.
be stalling for?
Objection's overruled.
Thank you, Judge. They got their side, their position, we've got our side. So we're gonna talk about that. But, and we're gonna talk about justifiable use of deadly force and non-deadly force, but either way, however you rule, it still justifies her behavior. And the result is not good. Now, I don't believe there's anybody.
Objection, proper argument,
Overruled.
objection to reproach.
Yes.
I think you will find from considering the evidence in this case that there is no doubt that Sarah Boone is a victim. That Sarah Boone has been traumatized. That Sarah Boone is still traumatized. And the reason for the trauma is Jorge Torrez. The reason for the trauma is Jorge Torrez. From the positive things about the man that we've seen on video, to the positive things Sarah Boone has testified about, to the violent monster he becomes. And I mean monster, because it was repeatedly. And what happens the next day? Man, I don't remember. I was drunk. I don't remember. That's the gaslighting. That this young woman, vulnerable woman with nobody, just starving for love, starving for attention, and seeing the good in the man. And it was good. But every day was on the balance. She measured every day, depending on how it started and then how it ended. And that's the way she had to live her life, day in and day out, day in and day out. Dr. Harper and Dr. Brandon talked about trauma. Dr. Harper spoke of the veterans that she had treated for post-traumatic stress disorder. I don't know if you remember her testimony, but she spoke about some of the veterans that had been in the war in Iraq, you know, and people in war a lot of times get post-traumatic stress. It used to be called shell shock and other things. But people in wartime, or police officers will get post-traumatic stress. And a lot of them come in, the males come in with this bravado, I'm all right. I'm all right. And so that's why Dr. Harper was talking about the veterans. That's what they'll do. But you got to spend time with them. It just can't be one session. And you've got to run post-traumatic stress testing, which tells whether they really have post-traumatic stress. And we all probably have experienced some trauma. All of us have lost some loved ones. And it's awful. You're in shock. You can't believe it. It's disbelief. You don't sleep for days. And eventually, you have to go back to work. You take a week off. Life has to go on. Life has to go on. You go back to work. Kids are in school. You get a little time, right? Time heals, right? These veterans that come back from a deployment, they get back, they get some semblance of normalcy. They may or may not get some treatment, but time helps. Time heals. Everybody, it helps. Just time. Overcoming a divorce, overcoming a death, whatever trauma. Sarah Boone had no break. No break. Learned helplessness. Just giving up. Just giving up. I can't get out of this situation. They broke up. She'd go about 2 days. She'd go about 2 days. Texting, calling. Just learned helplessness. And it's, in the manual. Battered spouse syndrome is not, but what did you hear Dr. Harper say? She suffers from post-traumatic stress. That is a mental disorder. You are actually undergoing the psychological effects of post-traumatic stress. You're not in your right mind, and it's repeating itself. It's repeating itself again and again, day in and day out. And when you look at this law, that's what you have to apply. Someone in Sarah Boone's shoes, when you're deciding whether her conduct was reasonable. Got a bunch of notes. Not bad. It was something I wanted to read. Where'd that put it?
Are you kidding me?
Sarah Boone's long-term exposure to abuse created a state of learned helplessness and diminished her capacity to assess risk, especially in moments of heightened stress. The cyclical nature of this violence, the tension building, the battering, the contrition phases, caused Sarah to be trapped psychologically in that relationship. Due to this clear abuse, Sarah Boone had a reasonable belief of imminent harm under her state of mind. George Torrez had a history of violence against Sarah, and as a result, Sarah Boone's actions were the result of fear conditioned by abuse she endured over time. The cumulative effects of long-term abuse, as we saw her behavior on the 2-minute Suitcase video, is a trauma response. Sarah Boone acted out of a sense of preservation. While tragic, it was not driven by malice, but a mind ravaged by abuse. And I'm going to ask you to try to understand. Try to understand. Sarah Boone being emotionally and psychologically broken, whose actions may have been misguided attempts at survival but not murder. Imminent danger, her response reacted to that belief. It's somebody suffering from the long-term psychological effects of domestic violence. Who spent a lot of time? Dr. Brandon, you remember him. He was the first expert on trauma. Took some notes. Kevin Beck, you remember, did the direct examination of Dr. Brandon. He was from down in Miami, I think. He talked about the trauma that you cannot escape from the abuse, so you develop coping skills to protect yourself, knowing that the bad things will happen to me. It changes your behavior, not only your behavior, but your thinking, your subjective thinking about fear and what to do. And if you remember, Dr. Brandon said it's all about that person's perception, okay? A lot of times they will self-medicate with alcohol or drugs. A lot of times they suffer from anxiety. Basically, he said the trauma ends up being terror because you do not know what to expect. You do not know what is going to happen that night. It may be a great night. You may drink, and both of you have a great time. He falls asleep, passes out, you fall asleep, passes. But it may turn by, depending on his mood. I don't know if you could tell, she would try to placate him. Dr. Brandon said, you know, when you're trying to evaluate somebody, it takes time to get them to trust you. And the ultimate goal, he said, is to be a behavioral detective. If you're a forensic psychologist, is to be a behavioral detective. And the ultimate goal is to put yourself in the abused person's eyes so you can better understand their world. But ultimately, it's their perception of danger. Their perception of danger is what you have to look at. What a reasonable person would do under their perception of danger. Now, I want to go on. Trauma experts explain how victims' reactions in moments of stress are the product of the damaged psyche. Her actions, although tragic, and it was a tragedy, George Torrez lost his life in that suitcase. It's a reactionary response to sustained trauma. It's as if Sarah was acting out of a deeply ingrained fear and helplessness developed over the years. So it's a desperate need for survival, but battered women do things to keep the peace from time to time. And when they feel like they have a small portion of momentary power, they may enjoy that by vocalizing their position to the abuser. Sarah Boone's not perfect. Sarah Boone would argue with him, talk down to him. Some would say was somewhat abusive to him. Sarah's not charged with that. Sarah Boone is not charged with that. And I want to read you something on that subject. Essentially, okay, I don't know where it's at, but I'm gonna have to come back to it. But essentially what it said was, eventually it's been a 2-week trial. I got a bunch of notes. I'm trying to get this right. I know it's important. What I wanted to say was someone can be mean and angry and hateful, and intoxicated, and still be abused. They're not mutually exclusive. And mutual abuse exists where one is abusive towards another. And eventually the victim, Sarah Boone, trying to fight back against the abuse, became verbally abusive. While the victim has committed verbal abuse, it is important to remember that they, Sarah Boone, are the victim and have been pulled into an extremely vicious cycle where they are trying to survive. Sarah Boone intentionally left Jorge Torrez in the suitcase. What's the act of a battered spouse syndrome woman? She went up to her room, she fell asleep, and passed out. These actions are disconnected. Ultimately, she didn't let him out because of her fear that she knew if he got out in that moment, what he would do. That's real fear, that's real trauma that she was experiencing at that time. Now, I talked to you about force being used. And I think I talked to you about blocking an attack using a physical restraint like the suitcase to block somebody's attack. And the example I give, I got a couple of examples that may or may not apply. Let's say you're in a bar and you got your buddies and the other guy's got their buddies and they're drinking and it ends up being an argument between two of them. And you realize that these two are fixing to get in it. Well, one of your buddies comes around on the other side and grabs the guy before he's able to strike him, right? So you're committing an offense on this guy, but it's a restraint. It's a restraint where you grab him by the neck and try to get him out the bar. So yeah, you're committing an act, but it's designed to defend another, which is legal. Or let's say you have a situation where you have a police officer and he's on patrol. You know, he's in uniform, he's wearing a firearm, and of course he's got the bulletproof vest. And he goes to a call where there's a suspect that may be armed. And so he gets there, he gets out of the squad car, he's walking around. Of course, he's taking out his gun because he realizes he may be armed. And eventually he sees the suspect, and the suspect reaches for his waist. Now, in that moment in time, that officer has to make a decision. Am I going home with my family tonight? And I asked Dr. Werner about this Vaseline thing he's called fear response or fight or flight. You know, those decisions are made, it's instinctive based on your set of circumstances. she instinctively reacted to her unique set of circumstances to save her life or save herself from another one of these. I'm 63. I can't imagine that. I can't imagine that. Her father's not around. I need to talk about the case a little bit. And if you'll remember, I'll get back here. If you'll remember, lost my place here. Let's start with the witnesses, and then I'll talk about sin. But the first witness out of the box for the state, if you remember, was Juan Torrez, the brother. Remember that? It was some time ago. I know it's been a while. Y'all taking notes. You may have to go back. Their first witness was a good witness for us. Their first witness in their prosecution of Sarah Boone for murder was a good witness for us. Remember Tony Henderson did the cross-examine of Juan Torres. Asked him, what did you hear Sarah Boone say? Juan Torres, she was yelling, he's been choking me. He's been choking me. Mr. Henderson said, did that surprise you? Juan Torres said, no. That family knew what was going on. The police knew what was going on. The neighbors knew what was going on. Pearl Walker came in here, 80-something years old, in a wheelchair. Kevin Beck called her up. She saw it. Is there any doubt? Is there any doubt? I tell you why there's no doubt. In cross-examination, I got Dr. Warner to even admit. Did you hear it? Yes? Okay, Mr. Owens. She suffers from battered spouse syndrome. Wouldn't admit it on direct. Well, maybe I don't really know. I hadn't had enough time to really see her. You hadn't seen the pictures? You hadn't seen the 2-minute video? You've seen her one time earlier this month. One time. And she's going to start testifying about stuff she's never said before until she showed up in court? About, well, based on what she told me, I don't think she was in imminent fear? Come on. This is a courtroom. This is a courtroom. Good thing y'all are here. Thank you. But it gets even worse than that. It gets even worse than that here in this courtroom. The state attorney referred to these pictures. And I was going to rise up and
Overruled.
show these pictures to you.
Overruled. You may proceed.
That I was gonna rise up and show these pictures to you. Well, yeah, I'm gonna do that. They put her on trial for murder. But what did they say? And I gotta turn to this, make sure I get this exactly like they said it. I took a bunch of notes. Let me make sure I got this quote.
But I can't find them.
Can't even find it. But it was something to the effect, maybe Jorge Torrez is the battered spouse. Can you believe it? Can you believe that? Now you know why we're here. Now you know why we're here. Little boys learn early on that girls are different. You do not put your hands on a girl. You can't wrestle with them. You can't punch them. You can't kick them. You can't treat women that way. When you become adults, I don't care what she does to you. I don't care what she says to you. If she gets in your face, whatever she does, you do not have a right to hit a woman. No, sir. What has the state attorney tried to do?
Protection, proper argument,
Sustained.
What have they done?
protection.
What evidence have they tried to put on?
Overruled.
What evidence have they tried to paint Sarah as? What evidence? Controlled and manipulated were the words they used. You know, this ain't the 1900s. This is 2024. What's all these text messages? Why is that relevant? What are they trying to claim? She provoked his violence? She provoked his violence. Isn't that what they've done here in this trial?
Proper argument.
Sustained.
Let me get back on this. Abraham Marino. I don't know if you remember him. Abraham Marino changed his statement. They took a statement from Abraham Marino in which Sarah stated, I don't know if you remember, but it was when the police were all there. I think they got the tape out, and some neighbors were coming around, and there were 2 or 3 neighbors sitting around. He said, Sarah came out and stated it was an accident. Okay? Well, then, it was an accident. This Abraham Marino knew Jorge Torrez from Philly. Okay? They were friends. They would talk either at the complex, or if Marino went to Hall's Ace Hardware or Ace Hardware, what it's called. The state attorney Notify us.
Judge, I'm going to object to reading from things that are not in evidence.
Approach.
I think what he said, he's going to object to him doing stuff that's not in evidence. Thank you, Scales of Justice, for your super sticker. What is she smiling about? Because James Owen has a way of making her feel good. Is that what it is? That's so strange. Who was that yesterday that won the earbud drawing? And their name. Oh, there you are, Kristen Kennel Club. Kennel Up, Idaho. Kristen, will you get an email address from either Bama? Well, I think Laura's got my email address. Would you email Laura your information? Because I didn't get an email from you yesterday, and I know you were here. I want to mail those earbuds to you. And whoever who won today, I got your email. I already found it. So thank you. SR says, who is on trial, Sarah or Jay? Right? So ridiculous. With every objection, a wacky streak of Sarah Boone's hair comes undone. She looks so rough today, you guys. Big time. Done. Thank you for your super sticker. Owens will introduce essay from Sarah's father and brother. I would not put it past him. This man he's capable of anything. He's one of those. Anything he's got to do to win. Roxy Franklin says ex-husband got to talk to Kranick on break. Oh, thank you for that info. Where did you hear that? Twitter? So has Brian's been in the court? They're not going to do any sentencing even after the verdict comes in. I wonder why Kranick was talking to him yet. That's interesting. Interesting. Thank you guys for your super stickers. He keeps jumping all over the place, you guys, though. It's not like he's giving a statement that's making any sense, really. Yeah. Okay. So Laura just put her email in the chat. So if you could email her. Oh, and Linda put hers in there too. So if you could email one of them your mailing address so they can get it over to me so I can get you the earbuds. Thank you. Sent message on Instagram. Well, I didn't see it on Insta. Dang it. Why does it do that? Oh, I found you. Okay, never mind. I found you. All right, thank you. I have a bunch of people trying to reach me on Instagram. I apologize, you guys. I didn't realize. So what do you... He's basically turned down all the objections so far. So is he going to come back and say everything's good? Go ahead. But he said something about not in evidence. What wasn't in evidence that Owens mentioned? Because he lost me. I'm not gonna lie, you guys. I don't know where this man's at.
You may proceed.
So for 4.5 years, Marino says, all I heard Sarah say that afternoon was it was an accident. Then he came in here today, or this week, and said, no, she said I was teaching him a lesson, things got out of hand, and then I fell asleep. 4.5 years later, we know he's friends with Torrez. We heard it here. Now, I want to talk to you about the two boys that live right next door. You remember Vincent Battaglia and Brandon Motes? Remember those guys? And you remember it came out in testimony, you know, this event happened on February 23rd of 2020. But it came out in the testimony that Sarah had said, Jorge Torrez, the night before, February 22nd of 2020, grabbed me by my hair and pulled me down the stairs in my apartment from top to bottom, which is consistent with what they were saying happened, remember? But they got their dates wrong. And remember, Mr. Henderson called Deputy Copsel or Detective Copsel up in our case, and she had to say, yeah, I didn't take their two statements until the 27th, February the 27th, remember? So they're remembering back, and they both had similar stories. Of course, they had time to talk by then, the 27th. I think the only recorded interviews they got that the night of this event, February 23rd, was from Sarah Boone and her ex-husband, Brian Boone, right? So they came back following up on the 27th. That's when they got a statement from Brandon Motes and Vincent Battaglia. And at that time, they said, yeah, we heard that sound. You remember Sarah testifying? No, that was the night before. I complained about that, and I think one of them had testified. Yes, she had said something about being drugged down the night before. It may have been, can't remember now who it was, one of them. And, you know, it looked like that there may be some implication that Sarah got him in the suitcase and pushed him down the stairs. But I think we didn't have anything more of that. Remember? And then this photograph, which we introduced, which shows the bottom of the stairs. As you can see, there's Lucas's bookshelf right here. This is where Sarah Boone stored Lucas's stuff. You can see it's not disturbed at all. Anyway, I want to get back to Sarah. I want to talk a little bit about that. But let me talk a little bit about the law. Unjustifiable use of force is legal and lawful if you reasonably believe, I think we all probably already understand it by now, you reasonably believe it was necessary to prevent imminent threat to harm. The law is crucial, ensuring that individuals can safeguard themselves in potentially dangerous situations. By acknowledging you have a right to defend yourself when you have a reasonable belief that force is necessary to prevent an attack. Okay? What did Mr. Henderson say in jury selection? You don't have to wait. You do not have to wait. If you're facing, in your mind, a reasonable, imminent threat, you don't have to wait. Let's talk about Sarah Boone and this unconventional form of physical restraint to block the attack of Jorge Torrez. What did she say? You saw it. Now, you got to think about that. You got to think about what was going on. You got to think about the trauma she was undergoing. You got to think about they've both been drinking. And you got to think about the fact that it was all fun and games for a while. And I think the biggest thing to know is that Jorge Torrez chose to get in the suitcase. He's a grown man. That was his choice. She didn't force him in at gunpoint to get into that suitcase. He voluntarily got into that suitcase because they were drunk and being silly and stupid and playing hide and seek. Which I guess when you get so drunk, that seemed like a good thing. zipped him up, they're laughing, carrying on. And as you know, Sarah likes to videotape a lot. And I know you've seen some of these videos and you're wondering why, but I think the evidence shows that when George is being videotaped, he's not going to do anything. If you think about that, when George is being videotaped, that's like her power. You know, Dr. Harper said that Sarah's words are her power. Sarah's words are her power. Physically, she's no match for George. Physically, she's no match. But that's her power, is her words. When she gets a chance, to have some control, that's what she does. And she videotapes because she knows when she's videotaping, she can tell it like it is. I can tell him what I want to tell him. A couple of these videos you've seen, she's telling him like it is. But she's got that video camera on, and George knows he's being videoed. We've got one that we're going to show you in a little bit, where he loses it just a little bit. Right at there. And of course, we got the TV. But they're kidding around, playing around. Then, Sarah realizes, okay, this is my chance to say something to him. So she sits down, she turns on the phone, and you've seen the tape. You've seen the tape. For everything you've done to me, are the first words out of Sarah's mouth when the video begins. There's a lot packed into those words. Think about that. For everything you've done to me. This is how it feels when you choke me. Now that's in direct response and the result of the abuse that she has suffered at the hands of George Torrez. She wants him, for that moment, to feel how she feels. She wants, for that moment, to feel, for him to feel how she feels, how uncomfortable, lack of control that she feels when George is violent with her. Just for a moment, she wanted to give it to him. And if you can imagine,
Approach.
I think from the evidence, you can determine she was crazy. She was crazy about that. And I don't know if, of course, it's a syndrome, but she felt like she couldn't do without it. And let's say she videotapes him, and then it's turned off. And there's a 9-minute gap, 11-minute gap, whatever it is. I said 11, they're saying 9, but I think if you count 2 of the other, then that's not. But there's 9 minutes that we don't have video. But what did Sarah say? Now, if you remember when you listen on that video, George is talking in a normal voice. He's not stressed. Of course, if you're talking, you can breathe. She had said she had some air. And of course, she doesn't realize the situation, that it's going to end the way it ends. So she has no appreciation of that. It's a canvas. All she knows is an old canvas suitcase that she's got some, the 2 zippers removed or spread out a little bit so she thinks he's not being serious. But eventually he gets angry. She gets angry, he gets angry. He says words to her, and then his hand starts to come out of the suitcase. She also said his tone changed. And I know everybody's got a cadence with their spouse or boyfriend, girlfriend, but you know what I'm talking about. We've got a way of talking to people. We've got a way, your wife, your husband, you know each other. You know when they come in from work, what kind of mood they're in. Just by a couple of things, the way you just sense it, right? Well, especially somebody as hypervigilant as Sarah and as hypervigilant as a battered spouse woman would realize that he can flip the switch at any time. When I get out of here, I'm going to end you. And he realizes he's getting out. He got his hand out. At that moment in time, in Sarah's mind, that's an imminent threat. So she's got a justifiable right to use force. What did she do? She went over there and grabbed it. She lifted it up. She tried to get his hand back in, remember? She tried to get his hand to go back in. Wouldn't go back in, so her son's back was 3 feet away. Where the police found it the next morning. Same spot. No attempts to hide. No attempts to delete phone. No attempts to tamper with evidence. Nothing. In the same spot as it was. She picks up the bat. She pokes. She pokes him hard, trying to get him to stop trying to get out. And eventually he does. And you've seen the blunt force injuries. You saw some of the circular injuries where you can tell there's a poking. I think it's right around here. And she poked him several times. You remember the pathologist said, I think, maybe 5, 6, or 7 times. She pokes him. And he's got some scratches. I don't know if they'll let you look at it, but on the back of that suitcase, it's got some bars, some metal bars that are inside the lining. There's some lining. And it's for support when you walk in. She testified. You heard what she said, that she was justified. That's uncontroverted testimony. Now, let's talk about the jury instructions just for a minute. And, I want to talk about reasonable doubt for a minute. Can't find the page, but I've got one. I've got one here. Let me find it. If y'all are all looking. I think it's on page 15 of 22. And we're going to talk about reasonable doubt in a minute, but if you look at those bottom 3 short paragraphs, it is the evidence introduced in this trial and it alone that you're to look for the evidence or look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence itself, a conflict in the evidence, or lack of evidence. But here's the main thing. And, obviously, I represent her, and I'm trying my best to show you honestly and fairly the doubt in this case. And 5 reasonable doubts, 17 reasonable doubts, 25 reasonable doubts. You have to have 1 reasonable doubt. I'm trying to show you throughout the evidence that each one of you can have a different reasonable doubt. Difference, but 1 reasonable doubt about the state's case, and your verdict is not guilty, according to law. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, speculative doubt, or imaginary or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. And this is a deeply held belief. Reasonable doubt is the highest standard we recognize in litigation. Car wreck or something like that is preponderance of the evidence standard, 51%, you're entitled. Abiding conviction. That's a deeply held belief that you must have if you're thinking about something. That's a firm belief. That's a level of certainty that you would have. That's what you got to have as a juror. I've got to be certain of her guilt. If, on the other hand, if after carefully considering, comparing, and weighing all the evidence, which we want you to do, there is not an abiding conviction of guilt, so I'm not certain. I'm not certain of her guilt. Or if you have a conviction, I think there's some evidence of guilt, but it is one that is not stable, one which wavers and vacillates. One which wavers and vacillates. Then the charge is not proved beyond a reasonable doubt, and you should find the defendant not guilty because the doubt is reasonable. You understand that? You've got to be certain of guilt. That's the high standard we recognize. If I've got some evidence of guilt, so okay, there's some evidence for conviction, but it's not stable. It wavers and vacillates. Then under our system, you've got a reasonable doubt. And you've got the power and authority and the obligation under the law, if that's the way you feel, to vote that way. Later in the instruction, it goes on, it's up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You may rely on your own conclusion about the credibility of a witness. That is totally the province of the jurors to decide that. A juror may believe or disbelieve any or all the part of the evidence of the testimony of any witness. I want to show you this before I forget it. But Dr. Warner said, this is their expert again. He testified that Sarah Boone suffers from battered spouse syndrome. Battered women's experiences affect her perception of imminent danger. Those past experiences with Jorge Torrez, and there's a bunch, affect their perception. Remember Dr. Michael Brandon talked about perception of imminent danger. Victims of repeat violence may fear death in situations others would not. The reason Sarah experiences all this, the reason she was feeling the way she was feeling, that imminent threat of danger from Jorge, was because of Jorge Torrez. Jorge Torrez is responsible for her mental state because of the way he has violently treated her. She reacted to his attempts to get out because of the way he treated her and the way she knows what is he going to do if he gets out of the suitcase? She knows. The second video is played. She's flipped it back upside right. You hear him, it's 22 seconds. He says, Sarah, she's not going to open that suitcase. She's not going to open that suitcase. He's already threatened her. She used the bat to get him to stop trying to get out of it. Why would she do that? Why would she do that? I know what he's going to do. I know what he's going to do to me. I know him like I know more. I know him more than he knows himself. I know what he's going to do to me. You don't have to wait. That was justifiable. Now, you got to understand this. She intentionally used the bat to defend herself. She intentionally didn't unzip him. to defend herself. Both of those are lawful under our law. She went upstairs. The dogs were upstairs. At some point, she called her husband, or ex-husband, Brian Boone. We know that many times she testified, or somebody in court said she would often flee to her ex-husband's house sometimes. I believe that testimony came out from either Sarah or somebody. That sometimes she would flee, or sometimes she would flee to upstairs. One of those two. But the dogs were up there. She made a phone call. At some point, she fell asleep, passed out, fell asleep. We don't know. They had 2 big bottles of wine, right? That was unintentional. That was unintentional. His death was unintentional. You remember when she was in the interrogation room? You remember that? Now, I don't know if we did a good job of this, but it came out that she got arrested. You remember the one time when she got the black eye? She got arrested for strangulation. And you remember that? They ended up over there by the dryer, and he was banging her back of her head on the floor that had very little carpet on it. And she ended up getting her arms out, and then she grabbed his neck. And she eventually got him off of her. And that's when he got up and stomped her in the eye. Remember? Well, the police came for that event, and they took statement, and Sarah was honest with the officers about what all, and they arrested her. You remember? Remember that? They arrested her. And she said, why? I was fighting back. You remember that? Why? I was fighting back. So from that point on, she didn't trust law enforcement. The video that they showed a while ago about George, that was about dropping the case, where she was defending herself and fighting back. I want to talk about this investigation by law enforcement. Now, she didn't know the law. She's not a lawyer. She gets up the next morning. Brian's calling. Sarah's got to pick up Lucas at 3. Brian's calling. Eventually, she walks down. She's looking for George. Where's George? He's quiet down there. Then she looks in the bathroom. She looks out. He's smoking a cigarette. He's on the computer. She sees the suitcase. And you can imagine.
Objection, overruled.
Sustained.
She sees him in a suitcase. She panics. What does she do? What does she do? She tries to get her fiance out of the suitcase. They're engaged to be married. She's not trying to kill him. They're engaged to be married. She gets him out. She tries to do, he's purple. She tries her best to do CPR. She doesn't, you heard her, I didn't know what to do. I didn't know, call Brian. That's her safety valve. That's all she's got. Brian eventually says she's come over. She calls again in 2 minutes. I'm on the way. He gets there. You got to call 911. May have told her before. Call 911. She calls 911. She tries to do CPR again. Is she busy trying to hide evidence? She busy trying to hide evidence? She busy trying to hide the back? No, she's trying to save his life. If she can. So the police get there. She knows If she told him, she fought back, she's gonna be arrested. That's what happened before. What happened before, like George has said on the video, she'd never been arrested before that time she was charged with that with George. She lies. She lies. She's scared. She's scared. She doesn't know what to do. So she lies. She makes a decision to lie. Don't trust law enforcement. She doesn't know the law. She doesn't call a lawyer. She talked to Officer Rodriguez, was the first short black female that came up here first, the first one that arrived with body cam. Talks to her. There's a recorded statement there where she doesn't tell the whole story. She lies. And then the detectives eventually get there and get her in the squad car. You hear the audio. I think it was played. She lies again. Then the next day, she goes down to the sheriff's department. Now, if they would have told her, hey, ma'am, we're going to arrest you, and she gets a lawyer to go down there to make a statement, and the lawyer would advise her.
Objection. Facts on evidence.
Sustained.
Move to strike.
Stricken. The jury will pay no mention or give any weight to that statement.
She's not a lawyer. She didn't have a lawyer present when she made this statement. She didn't know the law. She didn't know she was justified in defending herself the way she did in this dysfunctional, toxic, abusive relationship. I don't know if you remember, it was a 2-hour video, but there were some things she said, it was not intentional. And eventually, she wanted the detective, it was Detective Lowen, the male detective. And she said, I swear to you on my son's life, it was not intentional. What she was talking about was that George passed, was that George died. That was not intentional. She thought he was fine in there. Would he sober up? We've learned from their history, when Sarah gets drunk, she calls for help. When George gets drunk, he beats Sarah. That's their pattern. How many times do we see Sarah call the law? That's their pattern. Sarah told him, I didn't know, I think she said, I didn't know something like this could happen. I've never done it before. And Detective Lowen said, well, what did you expect was going to happen? I've got a daughter that she's about 18 or 19, and she got a grandmother's hand-me-down pickup truck. And it was an older truck, but she didn't have it long, and she was gassing it up, but she didn't put any oil in it. Eventually, it burnt the motor. And you don't know what you don't know. I hadn't done a good job of explaining, hey, you got to put oil in it too. Sarah Boone didn't know that he could die in there. It's an old beat up canvas suitcase that she left a gap in. And as naive as that sounds, she didn't appreciate the danger. I mean, is that the way you want to kill somebody? Is that the way you're going to do it? She had Lucas to take care of it. Am I going to go to prison doing it like this? No attempt to hide the crime. I think the evidence is clear. That's how this happened. belabor the point. I do want to show you. Just quickly show you the injury. Sarah Boone got stabbed. Think about that. Stabbed with a steak knife in the leg. And she stayed with him. She stayed with him. Poked between the eyes with a curtain rod. Stalked in the eye. And who does that? The law empowers an individual to defend their life and safety when faced with a threat and to prevent an attack. That's what Sarah Boone did. That's what Sarah Boone did. I think it's important to understand Sarah had to be the parent a lot of times. It was her place. She had that $1,000 a month from the divorce settlement coming in. She had the car. She had the phone. She had the keys. She had to be the parent in a lot of ways. I want to talk a little bit about Dr. Harper. If you remember, Dr. Harper is from Okaloosa County, which is up in the Panhandle, close to where we're from. And she's the doctor that treated Sarah from early on. Remember, this happened in 2020. I think she first saw Sarah Boone shortly thereafter. And over the 4.5 years, saw her 9 times and did all the testing for post-traumatic stress. Of course, she has the experience from veterans, and she's testified that she's now just traveling around the state, testifying as a forensic psychologist. But she talked about how important it was to develop trust with the patient over a course of time. It's just going to take time when you have somebody suffering that kind of trauma and that kind of damaged psyche. It's going to take some time to get them where they can trust you and really tell you and talk to you and tell you what's going on with them. She talked about that Sarah uses her words with power. I think her testimony, I think the evidence supports that her testimony was credible.
Objection.
The evidence supports that her testimony was
Objection
credible.
is sustained.
I can't give my first name. Okay. The evidence supports that her testimony was credible because of the time that she spent. because of the number of tests that she did. And she diagnosed him with post-traumatic stress disorder, alcohol use disorder, I think anxiety disorder, and battered spouse syndrome. Dr. Warner confirmed that. And, Dr. Michael Brannon, the first witness, he was brought in as a subject matter expert. So he hadn't treated Sarah. He was just testifying about the condition. He's been doing it a long time. He's an expert at it. And that's to advise you to try to understand what's going on. And as crazy as it sounds, in this syndrome, they try to protect the abuser. They're in love with them. They try to protect them. I don't know if you remember, but there was a time where Sarah Boone had a conversation with one of the neighbors, and they were talking about something. She said, "Did you hear anything yet last night?" Remember, she said, "Shh, it's okay." Both George and Sarah lied to the police. They lied to medical people. I don't know if it's shame, but it just comes with syndrome. That you stay trapped in it. I think another big, if you'll think about this. When Sarah gets beaten by George, she calls the police. When Sarah gets beaten by George, she calls the police. And a lot of times she just wants him out. Just get him out. Get him to leave. She doesn't want him to get in trouble. She just wants him out. There never was a report of George calling the police on Sarah. She wasn't physically abusing him. The state is trying to present evidence. Did she emotionally abuse it?
Sustained. Stricken. Members of the jury will pay no attention to that comment. Give it no weight whatsoever.
I believe the evidence that's been presented by the state is an attempt to show that Sarah mentally or emotionally abused George Torrez. Again, she's not charged with that. She's not perfect. Some of that was her trauma. In Sarah's situation, you do become numb and hardened, I think, over time. That's a coping mechanism. It's a day-to-day thing, some good days, some, But the homicide detectives, I know if you saw that 2-hour video, at some point during the 2-hour video, they started talking about some of the violence. And they go, we know. They had already checked with neighbors or whoever. They knew. The neighbors knew. Police officers knew who responded. Torres' family knew. They all knew about the abuse. Dr. Harper testified that abused women act differently when they perceive a threat. I think Sarah Boone was loyal to a fault to George, even through all the abuse. Judge, I want to make a comment about a couple of things that were said by the prosecutor in opening statement.
You may proceed.
The prosecutor in opening statement, when he was talking about George Torrez passing away, he started talking about Sarah Boone. And his quote was, because I wrote it down, George, in Sarah Boone's mind, George Torrez deserved it. George Torrez deserved it. That's the position they're taking. He deserved to die. She loved the man. She wasn't trying to kill him. He also commented about.
Yes.
I'm sorry, I fell asleep. I'm just kidding. I was making coffee. You guys, he started. We've been recording for 9 hours and 50 minutes. He started talking in 8 hours and 8 seconds and 8 minutes. You do the math. I'm thinking the cutoff is 2 hours, and I think he's going to use every bit of that. But is he going to let Mr. Henderson get up and say one last thing? Can you hear me, Margaret? Do you hope I get some rest this weekend? I know. I got to. I might have to take a day off after this trial to catch up on. But see, I'm just as into it as you guys are. So it's like I don't sleep. I'm like, oh, I gotta get up and do this. I gotta get up and put this together so everybody can look at it and like because I have these ideas about these things that I want to put together, things that we've seen, and I still haven't done everything I want to do, and there's still a ton of stuff to do here. So I don't know if I'll ever get to it at this point. Silky Lily says I feel abused by Owen. I think we all do at this point. He is abusing his time for sure. I'm glad that Juan and them are okay. I'm glad that they're not like. I mean, it's been 4 years since he's been gone, but everything I saw about him, I pulled up his Instagram, you guys, and everything I saw about him, his family, he's so family oriented. I stalked Juan, I stalked Juan's Instagram. She's bitching about something. Look at her. She needs to go back to the dumpster. I'm sorry. She's trash. She's yeah. Hiss boo. If someone hires this guy based off of this, I'm worried. Well, you got to give him credit. He doesn't quit. I mean, you're still worried about that one juror, Cass? I'm not. I think she's probably, after seeing everything, she's probably pissed off enough to where she's like, you know what? I've got to tell these other jurors when I get the opportunity of what a DV victim goes through and how I feel that this is not the same circumstance that she was going through. Yeah, isn't there a spigot or a hose somewhere that needs to be Sarah needs to go to? Just tie her up next to the trough like the rest of the horses. I know. That's what I was thinking. Like Henderson's daughter, how is it that she's so pretty? I don't get it.
The prosecutor said in opening about the violence, the violent episodes. It's a bunch of violent nonsense, was his statement to you, an opening statement. All this here, the photographs, is a bunch of violent nonsense. You'll have to make your mind up whether that's that. There were a couple of exhibits that I introduced late, and they were no contact provisions, where there had been a court order from a judge, not only a verbal order, but it was reduced to writing. So there was a court order for Jorge Torrez not to have any contact with Sarah. Okay. Court system got involved. They're to have no contact with Jorge Torrez. Now, I need to talk a little bit about that. And they talked about coercion, coercive control, power and control, power and control. We know about his abuse. We know he destroyed the home, the TV. We know about his jealousy. You know, some of the things he said to her. We know about how he treated her dogs nicely when he was sober, but at times abused the dogs or threatened to do so. If you think about power and control, when you're controlling a person, and I think she testified that he kind of smothered her, was always around her. Part of his fear was her realizing that she'd had enough and to leave him for good. That she would get the strength over time if she had enough time away from him where she wasn't in control of it and he wasn't in control of it. Enough time away, she would come to her senses and realize she could do better. The judge has been giving court orders all week. I didn't stop Jorge Torrez. Jorge Torrez knew he was going to lose control if she had a bunch of time away from him. She might move on. He was willing to violate a court order to maintain control. That's Jorge Torrez. I want to show a couple of videos. And I want to say something to you. Andrew's just going to help me.
Oh,
You doing all
goodness.
right?
What has he got? I'm surprised he had any. I didn't think he did the way he was acting. He's going to say, what, did I just hit play? What do I do?
Do you understand? As of this moment, and until I can get you out, get the fuck out of here. You're a room. I dare you.
Did you see him?
Yep, look at it. Look, get away from me. Get away from me. Get away from me. I'm gonna scream bloody murder. I'm gonna scream bloody murder.
Did you see him flip the switch?
I saw him dunk from
In that
getting hit.
instance, where he lost it, even though the video was going. Show the next one.
Show the whole video.
Thank you. Thank you, Joe. You turn it off. Can you turn it on? Ladies and gentlemen, I'm going to finish up right here. And Sarah Boone, I've gotten a note.
Objection. Proper argument.
Sustained.
Sarah Boone is like any other citizen. Equal justice under the law. She's to be treated like any other citizen. fairly and impartially, based on the circumstances she was facing at the time of this tragedy, based on the battered spouse instruction, which is a special instruction that's given when women have a heightened sense of fear and trauma, that you're utilized in applying her subjective standard to the reasonable standard of what a reasonable person would do under her circumstances, in using the force that she used to defend herself. I hope I hadn't missed anything. I've tried my best. Sarah Boone fought back and survived. We ask that you do justice in this case and find her not guilty because the doubt is reasonable. I've tried to show you where the doubt was. I trust your judgment. We spent a long time picking the jury, 4 days. We trust you. We appreciate your service and your obligation to do your duty. You have the power and authority to right this wrong. That's what we're asking you to do. And give Sarah Boone some hope for a better life and freedom. Thank you.
Thank you, sir. Any rebuttal?
Yes, sir.
You may proceed.
I love how he's like, can you get all your stuff up, please? Yeah, thank you. Get ready to go. Just go and pack up.
Ladies and gentlemen, Jorge Torrez is dead because the defendant believed he deserved to be zipped shut in a suitcase so that she could make him feel how she felt when he cheated on her, when he choked her, and to hold him there as a captive audience, according to her testimony. Now he has to listen to me. Well, right out of the gate, there are credibility issues. Cheating to me means viewing pornography. Well, we saw cheating really means women. And the heated conversation on June 14th about these women in Facebook, and that is what leads to the arrest on June 15th. He's out whoring, Candy Crush, all the bizarre things that you see in her phone. He uses the legal system as a weapon at times. There's no denying that they are engaging in violent behavior, and it is over nonsense. It is smashing TVs. They call the police, and then they're standing there looking bewildered about what to do and who to say, and laughing and joking. Ladies and gentlemen, the courtroom is the place for justice, not a suitcase. The reason we have a jury system originally started with the idea that the king, the crown in England, shouldn't be able to go and incarcerate citizens on his whim. So it developed into a system where citizens would have to say, yes, you can take our fellow citizen. But the opposite is also true. A citizen cannot take another citizen's life because he or she feels like it. That likewise requires a jury to decide that it was objectively reasonable for a person of ordinary prudence and caution. Like Mr. Cacciatore argued earlier, battered spouse syndrome is not a license to kill. Past grievances, even being stabbed in the leg, so on and so forth, do not give her the license to kill. There are still laws in place about when and how this can be done in a justifiable manner. I want to talk about the most important jury instruction in this case that has not been discussed very well. Excuse me. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself. And we'll stop at that comment. The facts of the case that came from her own mouth, if she is to be believed, and we will explore thoroughly why you should disregard every bit of her testimony, from court to the detectives, to the 911 operator, to the doctors. Her testimony, if it is to be believed, the most favorable light that she has presented of herself, is that at the end of a Sunday fun day, where we are drinking, we're outside by the dartboard, we're doing puzzles, we're doing arts and crafts, and there finally comes a point in time where we're gonna play hide and seek. And he says, tag, you're it. Even though she's it, she goes upstairs, hides in the shower, eventually gets tired of being there, it's cold, so on and so forth, and she comes back downstairs. And as she comes back downstairs, she can see Mr. Torrez fiddling to place himself inside the suitcase to try and hide for this game. And the lid is not closed, and it's flapping. And out of jest, out of levity, undisputed according to her testimony, she comes over there and zips it shut. Whether it's 100% or enough for 2 fingers to get out, that is something that you decide as the jury. But there came a point in time where the fun and games was over. And Mr. Torrez told her that. Babe, I can't breathe. Sarah, babe, let me out. This is all on video. We don't have to imagine this. This is all on video, 1062. At that point in time, she is using force against him that is not justified. She is the initial provocateur. She is the aggressor under the law. And what level of force is it? I can't breathe. Not let go of my hand, not get your hands off me. I can't breathe. This is no different than 2 people, maybe they're buddies at the bar, similar to an example that was given by Mr. Ohm, who are wrestling, and one has another one in a headlock. And there comes a point in time where the person on the receiving end of the headlock says, that's enough, I'm tapping. Jorge Torrez was tapping, and she ignored it. And she was kind enough to tell you why. Out of anger, which translates to hatred, ill will, spite, just like that in jury instruction for second-degree murder. She told you exactly why. She got angry. Him saying, I can't breathe, babe, was what triggered her. Not a fear of imminent harm. Those are her own words. That is the law. These are the 2 paragraphs that solve this equation without getting up on a big whiteboard in college that's 30 feet long, 15 feet high, and a ladder, and somebody's scribbling Latin words and Greek letters for months and months to solve this huge, complicated equation. The equation is solved in 2 paragraphs. She is the initial aggressor. He is saying, I can't breathe. It is no different than a naked chokehold that she does not let go of. And she told you it's because I want him to listen to me. This is my bully pulpit. This is how he made me feel in the past. She doesn't describe it as teaching him a lesson, but that's exactly what she says. I want him to feel like I felt in the past. I want to tell him things. Ladies and gentlemen, we can play semantical games, but that is teaching him a lesson. Therefore, we have to look at the other 2 paragraphs. Because right now, plain as day, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threat use of force against herself. And what force are we talking about? Well, the threat of force that she tells you she was facing was him fighting for survival, him sticking his fingers out of the suitcase, him sticking his hand out. That is the threat of force, coupled with, I'm going to end you. Well, ladies and gentlemen, she is the initial provocateur. She is the one using deadly force against him. If I have somebody in a rear naked chokehold, they are entitled to use deadly force against me to break that chokehold, at least until we're separated. He had every right to say what he said. He had every right to exist and stick his hand out and try and survive to breathe another day. However, the use of force is not justified if you find that Sarah Boone used the force to initially provoke the threatened use of force against herself, unless she does one of two things. And she did neither. Not even close. The threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm. All right, let's give her absolutely every benefit of the doubt, which you should. This is a criminal prosecution. The state of Florida has alleged she committed murder. You need to do everything you can to look for reasonable doubt. But a reasonable doubt is not an imaginary doubt, a forced doubt, speculative doubt. So accepting that all of their past history, accepting the doctor's testimony and the limitations on what they reviewed compared to what we reviewed. We did a much more thorough review of the relationship than any of the doctors did in this case. So let's give her that first clause. Because of their past relationship, with George now fighting for his right to exist and saying that he will end her if he gets out, we'll give her that. But just like Mr. Cacciatore mentioned earlier, lawyers' words mean things to us, and they mean things to everybody, but really to us. Or an and. There's an and. Had exhausted every reasonable means to escape the danger other than using deadly force on George Torres. She did not use every reasonable means to escape the danger that now, after provoking him, that he was presented to her, according to her. She didn't pick up her cell phone and start walking, call 911. She didn't do anything other than, if you believe that is why she called Brian Boone, made a phone call to Brian Boone, and unfortunately, because of past history, he just ignored her drunken phone call. She did not exhaust every reasonable means to escape this danger that she created. She started it. She created this. Other than using the deadly force on George Torres. Now, this is a weird situation. This is not a rear naked chokehold. This is a suitcase, or as Mr. Cacciatore said, a box, or actually more aptly described it as a coffin. And when you secure somebody into a box or a coffin, you can still exert that deadly force on them from a distance. I'll give you a quick example from a couple of movies that I love. In 1977 in May, a movie came out, it's called Star Wars. They eventually called it Episode 4. In the first scene, there is this large, imposing figure that wears black armor. He is a government agent, and he is looking for some stolen classified documents. He picks a man up who he believes is responsible for this treachery and breaks his neck and chokes him to death when he doesn't tell him where the plans are. We all understand that. That is direct force we all understand. But what we need to understand is the force she's exerting from the couch. And then when she goes up to bed, she is still exerting that force on him. She set these implementations into motion and did not stop. So later in this movie that came out in 1977, another co-employee of this dark, imposing figure, Vader, insults his religion. He does not go to HR. He takes matters into his own hands and chokes this person from a distance. Ironically, while we're talking about force, it's the force. And then in the subsequent movie, he's like doing it from his office. He's killing his incompetent employees on different ships. Force, deadly force, can be exerted from a distance in this situation. So whether she's on the couch or whether she turns in for bed, she is still using that deadly force on him. She has not exhausted every reasonable means to escape this danger. Do something. You started this. You put him in the position where he cannot breathe. She's required by the law to do something about it. Not something, everything. There was no efforts in this case. None. Or, in good faith, Sarah Boone withdrew from physical contact with Jorge Torrez and clearly indicated to George Torrez that she wanted to withdraw and stop the use of deadly force. But George Torrez continued or resumed the threatened use of force. That did not happen. She never withdrew from physical contact. She is still, like Vader, choking him from the couch, choking him from bed. She never withdrew that force. Physical contact includes any restraint on George Torres's movement. She never indicated that she wanted to withdraw. Sarah, babe, I can't breathe. All right, if I let you out, are you going to come out peacefully? Since I started this, I'm the one that made you not be able to breathe. That didn't happen. So, ladies and gentlemen, this entire analysis about deadly force starts and ends there. She was the provocateur. These are her obligations when she starts it. She put him in fear of death. He is literally telling her, I cannot breathe. A couple other things about the law. Second-degree murder does not require a proof of intent to kill. Argument was made repeatedly that she didn't intend to kill him. That has never been the state's suggestion. Because why would we suggest we prove something that we don't have to? It's not her subjective belief. Well, Sarah Boone doesn't believe that this suitcase can kill him, even though he's repeatedly said, I can't breathe. It's a person of ordinary judgment who would know, is reasonably certain to kill or do serious bodily injury to another. A person of ordinary judgment who hears, I can't breathe, babe, Sarah, and his voice gets weaker 9 minutes later, you're on notice. This is statutory notice. Done from ill will, hatred, spite, or evil intent. Her words speak for herself. This was not out of fear. This was out of hatred and anger. Born out of all those horrible things that has been done to her and done to him. Understand it. We're not going to belabor the past. Is of such neighbor that the act itself indicates an indifference to human life. I don't care that you're saying you can't breathe. Fuck you. That's my name. Don't wear it out. Fuck you. It's second-degree murder. We do not have to prove the intent to kill. We have to, she intended the act. She intended the act of zipping him shut. She continued to intend that act when he said, I can't breathe. That act resulted in his death. That's a manslaughter, but then when you add in the hatred, ill will, spite, and the depraved mind, that's what makes it second-degree murder. And that 2-minute video is the textbook definition of depraved mind as we define it here in Florida. Voluntary intoxication is not a defense. You cannot feel sorry for her because they had 2 1.5-liter bottles of wine and then some from the leftovers from the day before. And quite frankly, she's blackout drunk. She's blackout drunk. She doesn't remember making the videos. She turns her phone over right to the deputy the next day because she doesn't know what's on it. She doesn't remember doing it. Another thing that we just haven't talked about much is her story. She can't be up in the shower hiding and taking a picture at 11:03 p.m., 9 minutes before the video. That portion of her story just doesn't add up. And what it shows is it's more like 20 minutes instead of 11 or 12 minutes that we know he's trapped in what turns out to be his coffin. Let's talk about her testimony at trial. And we'll talk about all the problems. A lot of her issues predated her relationship with Mr. Torrez. So it's not attributable to the trauma from Mr. Torrez with all the luggage she brought into the relationship. And listen to the way she talks. It's not splitting the bills. It's helping without argument. It's not cleaning up and doing Sunday chores. It's cleaning up so we can relax. It's a reward. She talks about him like he's a child. I need to lead him to the next activity from one to the other. And then you saw the videos, and I'm not going to belabor it, that we showed in rebuttal, but the relationship and the power dynamics speak for itself. He was treated like the third dog. And it might very well have been a dog that bit and was violent, but he was treated like a dog. Why are you leaning against my door? Get out of here. Go downstairs. You're worthless. You're garbage. They showed the part of the video where he slaps the phone, but that's after 5 or 6 minutes of being berated and dehumanized in a way that nobody should be treated. He just wanted to get in bed and lay down next to his fiance. Instead, get away from the side of my door, you useless dog. I thought it might be a good point in time to listen to the music. You know, when does Mr. Torrez get to decide what to do? I mean, she paints this picture that he goes off and does all these things on his own, goes and buys wine when he's not supposed to, does all these things when he's not supposed to, but when does he get to do what he wants? Suitcase downstairs for a week so they can donate it. What was in their lives that was preventing them from getting that suitcase to Goodwill or whatever? Neither one of them worked. What's going on? Lucas is over there on Mondays and Tuesdays. The story about the suitcase having already been down there is quite suspect, and we will get into that more. But again, it's not we went on a trip together, we had a great time. It's, I quote unquote, I recently took him on a trip. Then it comes down to the moment of truth, which we've already gone over. And it's just quite frankly inconsistent because she doesn't, there's no explanation for the picture. Her explanation at trial when I brought it up to her was, I just don't remember. I don't remember this period in time from the picture at 11:03 to when I was supposed to be coming down the stairs. There's a major glitch in her matrix. She shakes the suitcase. Please stop doing this to me. And then his hand gets out. Now she's the point in time where she gets angry and doesn't do what the law requires after basically choking him with his coffin. Beats him into submission with the bat and turns it back over. For the first time ever at trial, she says, I'm going to fucking end you, is what he said. She never told that to even her doctors. We've heard the arguments why she didn't tell the truth to the police and all that. And there's a lot of truth into the argument that was made. There's a lot of truth. When the argument is made that she didn't understand self-defense, what that means, what it comes across as, she makes this story change as she learns about it. When we apply the jury instructions to her statement, all 6 of them apply against her. Won't belabor this since it was discussed earlier, but did the witness have an opportunity to see and know the things about which the witness testified? Even at trial, she admitted that she was intoxicated for the first time. She went back and forth with the police about whether or not she was intoxicated and her standard of drunkenness and whatnot, but she was so intoxicated that she still felt the effects of it at 1 PM the following day. The medical examiner told you that alcohol dissipates in the average person. Everybody's different, tolerance, all sorts of things come into play. But on average, 0.015 grams per deciliter will dissipate every hour. So you can do the math. 0.015 times 14 puts her at 2.5 times the legal limit. For those reasons alone, you should not believe anything she told you. You should not believe anything she told the police. You should not believe anything she told the doctors. She was at 2.5 times the legal limit. She has a gap in her memory that's unexplained when I brought up the photograph at 11:03. You can't have it both ways. I don't remember 11:03 to 11:12, but I was upstairs in the shower hiding. Does the witness seem to have an accurate memory? Well, this ties into what we're talking about. But again, there's a glitch in the matrix, 11:03 to 11:12. Her memory is not accurate. By her own admission, I don't remember. She tells the police when they show her the video, I don't remember that happening. Was the witness honest and straightforward in answering the attorney's questions? I submit when we got off script, and by we, I mean with both attorneys, she wasn't as honest and straightforward as when it was a very directed and smooth examination. I came out of the gate with something that was off script. Tell me about Pamela Erickson. Tell me about Christine. Tell me about Crystal. Because she's the one that said cheating to her meant pornography. Well, ladies and gentlemen, you know, she knew exactly who those people were and that she believed that he was cheating on them with her. And apparently she is too with some guy named Ben. When I describe this as a violent, nonsensical relationship, that's exactly what it is. It's not to downplay the violence. She got stabbed. She had minor surgery. It got infected. Those injuries are real. But they just don't apply in this case. They just don't apply when you use that self-defense instruction when she's the aggressor, if it's to be believed.
Judge, object.
Approach.
Oh, he is killing it. He is doing an awesome job. You guys, I love what he said. He said he's already mentioned several times about not being able to believe what's coming out of her mouth. He said cheating set her off. She got mad. He wasn't doing what she wanted, she wanted him to do. So he called the cops. He said disregard all of her testimony. If it's to be believed, her testimony is she zipped him up, she taunted him, she hit him with a bat, she left him there, knowing he couldn't breathe. And then he says she sets the implementations into motion, and then she did not stop. Whether it was on the couch, in the bed, she still is exerting force. And then he brings up Darth Vader, which, kind of threw us all off, but that's okay. Suitcase being downstairs was quite suspect. He's going to go there. I've been wanting to hear what he thinks happened. And I think he's going to tell us that she threw it down the stairs, you guys. I think he is. He's going to say that. Because remember, what he's saying is not testimony. He could say these things. They're not supposed to be testimony. Oh, you're using your earbuds? Oh, awesome. So he said there's a major glitch in her matrix. The memes are going crazy on Twitter right now, you guys. Between that and Vader. She beats him into submission with the bat. She changes her story as she learns more about the self-defense laws. You should not believe anything she says. She doesn't have an accurate memory. She's not honest and straightforward. And they were in a violent and nonsensical relationship. And the thing that he's not ignoring her injuries. Whereas Owens was ignoring anything having to do with what Sarah did to George, So good. He's doing great. I think he's going to say she threw the suitcase down the stairs because he said something about what were these people and that they couldn't take that. Why was that thing sitting down there on this downstairs for a week? If it needed to be taken to Goodwill, why was it sitting downstairs for a week? He's fixing to say the suitcase was upstairs.
Overruled.
Let me say it loud and clear. Battered spouse syndrome does not have any effect on this case. It has no relationship to this case because she is the aggressor. She zipped him shut in the suitcase after he said, I couldn't breathe, she wouldn't let him out. Therefore, all of the instructions above that paragraph of however do not apply. They do not apply. Now, turning back to what I was saying, did the witness have some interest in how the case would be decided? Well, of course. 3 out of 4 panels that y'all came from indicated to the judge fear of punishment was more important than the fear of public speaking. It speaks for itself. She has an interest in the outcome of the case. Now let's talk about, does her testimony agree with the other evidence in the case? You do not have to accept this story. Let's pretend, as you should, because all 6 of these things, we haven't even gotten to the inconsistent statements. Let's pretend her testimony doesn't exist, and you just have to look at the circumstances. The testimony from the defendant is Jorge Torrez's head is here. You can stand if you need. You've been sitting a long time too. His head is here. His butt is kind of down here. His feet are here. And his hands and his knees are up here. He's in the fetal position, if we remember right. The hematoma on his head is on the left side. The bruises, the deep bruises on his back are on his left side. You hear that? That's solid. You don't have to accept that she put those marks on him when he was in there. The evidence doesn't support it. You can conclude she used this bat when he was outside the suitcase. You don't have to believe her when she said they were playing hide and seek. You don't have to believe her because she doesn't know the rules. She came downstairs, saw what she had done, and had all the opportunity in the world to clean up whatever mess may have been at the bottom of the stairs. But ladies and gentlemen, physics doesn't lie. She can't expect you to believe her testimony about the loud boom being the day before compared to her 2 neighbors who weren't drinking, who have no interest in the outcome of the case, who suffer from none of the infirmities of her testimony. She suffers from all 6 infirmities. When her neighbors say there was a loud boom that night, there was a loud boom that night. Did it shake the wall they shared in common? It shook the wall that they shared in common. Did she have any injuries consistent with being dragged up and down the stairs the night before? No. You saw the pictures the CSI took. You don't have to accept her story about hide and seek. Something made that loud boom. It takes energy to make a loud boom. Energy that could very well be in the form of somebody going down some of the stairs, all the stairs, in the suitcase, out of the suitcase. But that's what the evidence supports, is there was a loud boom that shook the walls and interrupted a FaceTime conversation that was so loud that the girlfriend on the other end heard it. Something loud happened. And then there was silence, according to the witnesses. And they can argue that Juan Torres' testimony was great for them. It's great for the state. She was screaming at him already at 7:30 p.m. She was already on her bully pulpit. And we know she doesn't need to put him into the coffin to get on her bully pulpit. There's video after video of her on her bully pulpit telling him how it's going to be, how you're going to live your life. Go take a walk. Do this. Do that. You don't have to accept anything she said. It's inconsistent that he received the hematoma to his head, his bloody mouth. How is his mouth getting bloodied inside the suitcase? That's protected from her and her bat. But that suitcase, a 100-pound drunk woman is not beating through the wood of that suitcase or whatever it is that's making that noise when it's thumped. Ladies and gentlemen, those injuries happened outside of the suitcase. Ladies and gentlemen, somebody or something went down those stairs. She has no injuries consistent with going down the stairs. He does. He has blunt force trauma all over him. You don't have to buy her story, and you shouldn't. The inconsistencies, I'm not going to belabor it. Your dinner is waiting him back. Let's just briefly talk about the experts, and we'll move on to the end. Dr. Brandon was absolutely fantastic. He explained everything that you all needed to know about battered spouse syndrome. And this isn't about whether one of them or both of them had battered spouse, because at the end of the day, she's the initial aggressor, and she had the duty to do the things that the law requires. But it does call into question the credibility of the past power dynamics of their relationship. Those videos speak for themselves. The officer in the last video asks him, dude, you're a guy. Why don't you do something about this woman, your wifey, who you don't want to rat on for beating you? He said, man, I'm not a beefcake. I'm not going to rat her out. There's countless examples, if you apply Dr. Brandon's testimony to Juan Torrez, that really shows you the power dynamics of the relationship. He was her violent pet. Dr. Harper, I don't find much quarrel with what she says about battered spouse syndrome, and nobody should. I mean, she's the expert. But she's not Ms. Boone's treating physician. She's not her treating psychologist. The way it was described in argument, and I believe from Dr. Brandon's testimony, was she's supposed to be a forensic detective. Get to the bottom of this. She's going to come in here at trial and tell you her opinion you should rely upon. With 9 visits, she never asked the defendant what it is the victim said that put you in imminent fear of death or great bodily harm. That's the crux of the matter, Doc. You're never going to ask her what it is he said or did for this grand jury instruction about threat of force or use of force? It's remarkable. And, you know, she didn't review everything that was presented to you. At the end of the day, it's your opinion that matters about this relationship. And again, we agree with Dr. Werner. It doesn't matter. She had the duty to retreat. She had the duty to take the chokehold off. And if it was too dangerous for her to directly take the chokehold off, she had the duty to do something else, everything in her power to stop him from dying, because she started it. She set it in motion. She used the force grip on him from a distance, the couch and from bed. It was her obligation to stop. She didn't. But Dr. Werner, she was called by the state of Florida after having evaluated and listened to the defendant give a similar story and concluded battered spouse doesn't apply. So she was never asked to delve any deeper into it. Given the information that she did have, the limited information, she agrees, yes, Ms. Boone has battered spouse syndrome, but it doesn't apply to the case because she was the aggressor and she did not fulfill her obligations. And really just your gut common sense. Go back to jury selection. In jury selection, there was examples about bullies day after day doing something to somebody. And somebody raised their hand and said, don't they have to do something that day? Don't they have to do something that day? And he didn't. After he was put in fear of death and told her he can't breathe, the imminent threat of great bodily harm and death she is describing to you is him fighting for his life to escape. She did not fulfill her obligations. There's details that matter. And again, not to belabor it, I mean, the evidence in the body-worn camera and the 911 calls, it's not offered to prove the truth of the matter of as who stated what. Who knows what happened between these two? You see them with the police. Can't believe anything they're saying. It's not offered to prove that she's a bad person. It's not offered to prove that Mr. Torrez is a bad person. It's simply offered to call in question the reliability and credibility of what she said about the past. That's all that it's there for. But there are some nuggets and some Easter eggs. There was an argument made during closings that Mr. Torrez knows not to do anything when being videotaped. Bizarrely, shortly thereafter, they showed a very edited clip of him attacking her and slapping the phone out of her hand. He knows he was being videotaped, and there was another video like it too. So to make the argument that he doesn't do anything, he's a good boy when he's being videotaped, it's belied by their own argument. They showed one of the videos. Learned helplessness. She seemed to control everything. I mean, his birth certificate, it gets torn up when he doesn't comply with her wishes. You'll see the rest of the text messages if you choose to delve into them. But I would suggest you don't have to, given the jury instruction about aggressor. Ladies and gentlemen, this has been a long 2 weeks, and you are making a very, very important decision for Ms. Boone, and a very, very important decision for Mr. Torrez and the state of Florida and his family. He's dead. She killed him. She's admitting she killed him to have this affirmative defense if I was justified. It was not justified under our law. She does not get to decide that she has a license to kill because of her past grievances. The law requires her to stop using the force that she started applying to him. And she didn't. She didn't withdraw. She didn't tell him he was withdrawing. She didn't use every means available to try and stop this from happening. She didn't. And you know what was in her heart. She tells you it's hatred, ill will, spite, and venom. This is not a self-defense case under the law. Go back and follow the law. You cannot feel sorry for her. You cannot feel sorry for him. You cannot feel angry at her. You cannot feel angry at him. It's maddening to see their relationship. It is maddening. Nobody would want this life for yourselves or your children. It is violent nonsense, but it does not affect what she did and what her duties were under the law that night. She wanted to punish him. She did, and then she left him there. And she had an obligation, if you even believe her story about the imminent threat for him fighting for his life, she had an obligation to do something about it and not just go upstairs and let him suffocate. Thank you.
Thank you both.
Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.